Now, the Ninth Amendment is very, very interesting. It says in so many words that just because certain rights are mentioned in the Constitution doesn't mean that citizens don't have other rights as well. Just because going to a baseball game is mentioned in the Constitution doesn't mean you can't go to a football game, to be silly about it. The interesting part about this is that, the Federalists opposed the Bill of Rights. They didn't oppose rights, they opposed the Bill of Rights. And the reason was they thought that if you wrote it all down, then it was going to be as though the citizens would be, well, these are our rights, and if they're not listed here, then we don't have any other rights. And that's not a bad issue. And so the Ninth Amendment takes note of that. And of course, the most important thing of all is the Tenth Amendment, which says in so many words that powers not delegated by the Constitution to the central government, nor prohibited by the Constitution to the states, reside in the states. This illustrates the concept you've heard me use before of subsidiarity. Subsidiarity, going to the lowest level, on grounds that people who live at the lowest level are most familiar with and therefore better able to solve problems that exist at that level. That too is part of our tradition. Now, it's really easy to make this list of rights and liberties. But the fact of the matter is, and this relates to earlier comments about pessimism, we have to apply these in concrete and specific situations. And we have to apply them in rigorous, explainable, understandable ways that are maintained and developed over a period of time. You can't, in 1922, say murder is bad, and then in 1932 say, no, murder's okay. There has to be constituency. There has to be there has to be consistency in all of this. And that basically is the challenge, of which I think we can say there are three. Most of us, myself included, we don't know what civil liberties we have or don't have. I'm a political scientist. If you ask me a question, I could give you an answer and be right probably 90% of the time, but I'd be wrong 10% of the time. I hope I don't sound arrogant if I say that you probably would be wrong 50% of the time. Or be right 50% of the time, whichever it is. But we don't know our laws. And as I said earlier, the Bill of Rights still has to be applied to proposed actions in complex situations. For example, Congress shall make no law respecting the establishment of religion. Okay, if a bunch of kids want to gather before homeroom, you still have homeroom these days in the morning, before school starts. If kids want to gather and they want to say a prayer, what's wrong with that? Is there anything wrong with that? Well, no, but it is a school building, and if they're using a public buildings to be paid for by taxes, an argument can be made that the government is establishing not a religion, but religion. And that's not exactly what the First Amendment said. But you see, it's arguable, and if the school board makes a rule that says these kids can't gather for prayer early in the morning, voluntarily or involuntarily, then is that not an example of the state, the government, interfering with the free expression of religion? Okay? Do you see how complex it is? I hope, all I can do is ask, do you see how complex it is? How it goes to feelings. It goes to opinions. It's not logical all of the time. Judges and courts try to make its logic, to make it logical or to sound logical, but it's not always going to be logical. I don't think any of us has to worry about the government knocking on our door and saying, hey, outside we got a platoon of soldiers that's going to live with you at your expense while they prepare to go up north and fight the French and the Indians and to keep you free. So, and that's really not a particular issue. What I've tried to do is to give an example of the fact that laws, liberties, have to be translated into action. It's nice to think that a judge or judges sit somewhere in a room and examine the facts and come to a decision. Well, the attorneys and lawyers who've said that allowing voluntary worship on school property is an injection of the state into the practice of religion would argue they have been very objective and they have made those decisions. The people on the other side would say they have not. So what do you do? What is the result? The result we often call politics. You all said in your statements, I wish that people in this country would simply spend more time thinking about doing the right thing. I'm not arguing that there is no right thing. I believe, on the contrary, there is a right thing. There is a right and wrong. And that politics should be very much influenced by what is right and wrong. But one can also argue that right and wrong, whether we like it or not, is dependent upon individual perspectives and individual points of view. And so civil liberties and civil rights, which we'll talk about civil rights more next time. Civil rights may be a little bit easier, but only a little. We'll have to see how that goes. Now, we talked about two problems with respect to civil liberties. One, that people don't know what their civil liberties are. And secondly, that the Bill of Rights, which is so important to our civil liberties, still has to be interpreted and applied. And it has to be interpreted and applied in conditions and under circumstances that are contradictory and that do not lend themselves to a purely logical form of analysis. Third problem with this is that, and the third problem is the most powerful, and that involves states' rights. We have never, ever, we have yet to solve once and for all the problem of the proper relationship between national government and state governments. We just never have done this. We have had debates about nullification, how states have the right to nullify a law that is against, they think is against their own state law. We have talked about concurrent authority. Remember, states and nations, so they both have authority in a particular area, which is the one that bears. The fact of the matter is this. The Bill of Rights applies to actions by the national government. It does not apply to actions by the state governments. Now, the states aren't free to pass laws or impose regulations that are against the Constitution, because the Constitution is the highest law of the land, right? But what applies to the national government might or might not apply to the state government. Have I made that point clearly? I hope. What I'm saying is that provision opens up a huge area for discussion and debate. Brown versus Topeka, 1952. Separate but equal school facilities are inherently unequal. Okay? Bang. Let's start integrating right now. Well, we don't start integrating right now. Because, fortunately, I would argue, though I feel badly in terms of its concrete results, we have laws in place that make it possible for the state to go and question what the national government has done. And you can go and form a religious school. Or you can form a school based on some other, where there is no discrimination based on race, just on race. Well, it doesn't say anything about gender. Doesn't say anything about this, or doesn't say anything about that. What I'm trying to suggest here is that the Bill of Rights, wonderful document though it is, does not enable us to deal with the full range of issues in a decisive way. We are getting interpretations by judges and legislators. Judges and legislators, despite what they say, are not perfect. Sometimes they're not even very smart. Sometimes they're very smart. But the fact of the matter is they do make mistakes and they do respond to demands of the moment, which they're supposed to do because this is a representative democracy and legislators are supposed to be responsive to the people who elect them. And they want to be anyway. Am I making some sense here? Again, I do hope so. Now, what we're getting at here is a larger problem, and this is where I want to end. The provisions of the Bill of Rights have to be incorporated into our political life. A statement of a right has to be turned into a law, which in turn has to be based upon, ultimately, upon a decision by a duly appointed, elected judicial authority, a judge, or the Senate, or the Congress, or a state legislature. In other words, it's not enough to say, you have this right, you have this right, this liberty, this liberty, this liberty. It gets challenged, and it has to become incorporated. Another way to put it, I don't like this terminology, is that the Bill of Rights has to become nationalized. And the way that is done is a right is challenged. It goes to court. The court renders a decision, and let's say it upholds the right. That means the right is now incorporated into our laws. Okay? The Fourth Amendment, quartering the soldiers, that's never been incorporated. There's never been a suit about that, and there never will be a suit about that. It hasn't been incorporated. So things, as I say, have to be incorporated. Now, in fact, you could say the Third Amendment, the Fifth Amendment, the Seventh Amendment, and the Eighth Amendment have never been incorporated into our political life. So, when it comes to civil liberties and civil rights, we are at this time seeking the incorporation of the Bill of Rights, obviously, and the action or the starting point for most work in deals that comes from the so-called Civil War amendments, the 13th Amendment, which abolished slavery, the 15th Amendment, which guaranteed suffrage, the right to vote, whether you were a slave or not, and the 14th Amendment, which produced due process and equal protection of the law. These involve adjusting the relations among the three branches of government at the national level. These decisions also involve adjusting the relationship between the national government and the state governments. That's a big problem. That is an extremely complex problem. And that is a problem that continues to occupy us. One could argue that most of the major issues we faced in the last 10 or 15 years involve civil liberties and civil rights. They are intractable and difficult problems to solve because, as I've said, they involve adjusting the relationships between legislative, judicial, and executive branches at one level, and then they also involve adjusting the relationships between the national government and the state governments. Now, that's really all I have to say about this subject at this time, but before I close, I would like to say one thing more. I'm feeling a little frustrated because when you teach a class online, as I'm finding, there isn't an awful lot of feedback. And I guess what I'm doing is asking for some feedback. If you'd like, there's space to where you can post things. And I'd like you, that would be nice, so we all could see who's saying what. But if you think of some things that are private, you could always send me an email privately, and I will keep it confident. As I said before, don't let me give you the wrong idea here. I think you're doing a great job, and I'm very pleased with you, and I hope I could say I'm even proud of you. It's myself I'm concerned about, and so I'd like you to help me with that. So, I'll see you next time. Thank you.